Yeah, please, Bhumika. Aniket, it is started.
Okay.
Yeah. So, please, Bhumika, we can begin. Bhumika, you can start.
Sure, sir. Apologies for the delay. Shall I start, Yogan?
Yes, please do.
Apologies for the delay, audience members. Greetings to all. BSK Legal, a very renowned and reputed law firm dealing in insurance law, commercial criminal arbitration, and many other legal fields, in collaboration with Briefcase, a study platform providing case briefs and legal study material, is proud to organize this webinar on the topic Nuances of Criminal Trial. For this session, we have with us our learned esteemed guest, Mr. Ujjwal Nikam, who is an Indian special public prosecutor who has worked on prominent murder and terrorism cases. He has helped prosecute suspects in the 1993 Bombay bombings, the Gulshan Kumar murder case, the Pramod Mahajan murder case, and the 2008 Mumbai attacks. He was also the special public prosecutor in the 2013 Mumbai gang rape and the 2016 Kopardi rape and murder case. Learned Ujjwal Nikam has argued on behalf of the state during the 26/11 Mumbai attacks, and in 2016, Mr. Nikam was also honored with the Padma Shri by the Government of India. We also have with us Mr. Aniket Nikam, who is practicing on the criminal side of law. Pursuing his LLM from New York University, he has appeared for Ministry of Defence in Adarsh Housing Scam before the Judicial Commission set up by the Government of Maharashtra. Mr. Nikam has secured anticipatory bails for various leaders like Dhananjay, Munde, and other actresses like Shilpa Shetty and Rajkundra. Mr. Nikam has successfully conducted and secured acquittal for National Congress Party MLA Suresh Lath and has appeared for the then Transport Minister, Mr. Gulshan in the Gharkul housing scam. It's a pleasure to have you both with us today, sir. We also have with us Advocate Sanjay K Chadha, who is the founding and managing partner in the litigation and arbitration compliance firm BSK Legal. And under his supervision at present, the firm is successfully handling cases in over 614 districts of India. He is also a renowned and well-established face in the media channel. Sir, you can kindly take over for the same.
Thank you very much, Bhumika. And first of all, I apologize to all for the delay in starting. We got stuck some technical glitch, and because of which 7 minutes late was there. From core of my heart, I welcome Adarsh Shri Ujjwal Nikam ji. So most welcome and grateful to you, sir. We have really, all the students have honored that you, students as well as lawyers, we are honored that you have taken out time. I'm so glad that you are here. And equally glad today to see Aniket. You know, many of us have seen him on television. Aniket, such an excellent orator. You know, I'm sorry, sir, I'll begin with Aniket only.
Yes,
It's a proud moment for both of you and all of us that, you know, we are really having both of you here with us. And today in this webinar, we are very, very, you know, proud that Mr. Sanjay Verma, who is co-chair India Safety leading group for the British Council, he is also, he's invited and he's here with us. I welcome you also, Mr. Verma. And sir, it's a great honor to, you know, we just heard Bhumika introducing you, and I know there are huge number of people there in the YouTube and here also. They all are, you know, very, very, I don't want to miss even this opportunity, and they are all are waiting to listen to you. Mr. Verma, welcome. We can see you. Thank you very much for taking out time. And so I was talking about Shri Ujjwal Nikam ji. The government has honored him with a great honor of Padma Shri. So today we are going to talk about the nuances of criminal trial and what best, who best in this country? I'm very proud today. Who best than Mr. Nikam will be there to talk about it. The entire process from FIR till the entire, investigation, the police part investigation, then later on, as we know, the preparation of charge sheet, and then becomes the trial, which is the main thing. And today we have got the government side, and I'm very honored that Aniket will tell us the nuances from the side of the, the
defense lawyer.
yeah, defense lawyer. That is what. And I just wanted to share with all of my friends. I've seen Aniket so many times on television screens where the way he presents. I remember one of his recent interviews with at Republic Television, where the way he presented was amazing. Sir, he is a gem, and we all are honored to have this kind of, such lawyers in our fraternity. So we welcome you that way also. So I would not take much of time, Ujjwalji. So we'll begin with you. And thank you very much from the core of my heart that you have accepted our invite. And we all are, all my students, everybody, our YouTube is having good number. Please, we all want to listen to you, sir. Thank you.
Thank you. Thank you, Mr. Chadha. Indeed, I must congratulate you first of all, because you are the person who brought the defense counsel as well as the public prosecutor on one platform. See, in fact, he's my son. But my wife today had asked me, why Aniket is going to a diff office, though today there is a holiday. You see, I had to concede that though I am a public prosecutor, I am moving throughout the state, and Aniket is practicing mainly in Bombay High Court. But we never come against each other. It's in professional ethics. And not only that, Aniket never represent any case wherein I appeared as a special public prosecutor, either in the High Court or the Supreme Court. But today on the one platform, now he is sitting in his office. I'm sitting at his residence.
Okay.
This is since
in Bombay.
In Bombay. Since
Yes.
since I'm moving throughout the states.
Yeah.
And whenever I had the matter in Mumbai, I used to stay in the hotel. I never go to his office. That is the professional transparency we have maintained. So nobody can point out any finger at us. Yes, there is a collision. No. So what I would like to emphasize to my dear students, that legal profession is such that we have to maintain high standards in the profession. Number one. Number two, sincerity, credibility. These are the most important factors out of our life. People are looking at you from a different angle. They expect from you, not only as a legal concentration, but at the same time, they are thinking that you are their philosopher. And therefore, I was practicing at Jalgaon. That time, and in 1993, I came for the first time in Mumbai on account of the serial Bombay bomb blast case. That time, Aniket was a school-going boy. But see, I still remember those days. I started my practice as a public prosecutor, and Aniket was doing his schooling education in Jalgaon. And at that time, when I was invited to conduct serial Bombay bomb blast case of 93, that was the first major attack in our India committed by the terrorists. Mumbai city was rocked by a series of the powerful bomb blasts on 12th March 93. And RDX is a highly explosive which was used in that bomb blast. Now, when I took the charge of this case, the first question that arose before me, how to establish criminal conspiracy? See, criminal conspiracy is the most important definition in the Indian Penal Code. For the students' information, I would say that section 120A of IPC defines criminal conspiracy when two or more persons agreed to do or cause to be done an illegal act or legal act in an illegal manner, they are constituted criminal conspiracy. This is the statutory definition of criminal conspiracy. But if I had to define criminal conspiracy in the simplest language, then I would say two persons cannot breathe together unless they put their heads together. This is the most important fundamental formula of a criminal conspiracy. How to prove the criminal conspiracy in a criminal trial, that is the most important thing. Now, it is very seldom to have the direct evidence on criminal conspiracy. Criminal conspiracy can be proved by indirect way or by the acts or the omissions committed by the co-conspirator in pursuance of the criminal conspiracy. Now, in 93 bomb blast case, the biggest challenge before me was how to establish a criminal conspiracy. When I perused the investigation papers, I found that time TADA Act was there. Terrorist and Disruptive Activities Act 1987 was in force. And Section 3 of the TADA Act was defining about the definition of terrorist act. The definition was so wide and exhaustive that it was covering almost all acts of offenses under the penal code. But the beauty of that act, that under Section 25 of the Evidence Act, if accused admits a guilt before a competent police officer, that is not below the rank of the superintendent of police, that would have treated as a confession. Some people, some accused persons had given the confession. Now in that confession, they have made the reference that meeting, first conspirator meeting was held in Dubai. And in that meeting, it was held to blast Mumbai city, RDX to be imported, and that meeting was attended by Tiger Memon, his brothers, Daud Ibrahim, and some three unknown people who were in fact the Pakistani people. And they went to Pakistan. They had taken the training, how to plant the bomb, how to open the fire, how to fit the time pencil detonators in RDX, etc., etc. Now, surprisingly, when the accused engaged lawyer, and naturally, the accused retracted their confession, the confession which was given before the police officer. So main task before me, how to establish criminal conspiracy. One of the mode, to prove the confession by examining the concerned police officer. And the other mode, to place the attending circumstances on record to arrive at a conclusion that there was a criminal conspiracy. Now, see, I learned one maxim, set a thief to catch a thief. If you have to catch a thief, you have to send a thief. That was an English proverb. Law also does something to some extent, because there is a provision under law in the CRPC to turn accused into an approver, to tender pardon to the one of the accused who was privy to the crime. Section 306 of CRPC to Section 308 of CRPC deals with law of approver. Now, law of approver, that says that prosecution investigating agency can turn into any of the accused as an approver and who is well acquainted with the facts of the case. Now, in this bomb blast case of 93, I had a discussion with the senior cops, and they said that there are two persons who are ready to become an approver on the condition that pardon should be tendered to them. In view of the provisions of Section 306 of CRPC and Section 307 of CRPC, pardon was tendered by the magistrate during the course of the investigation and by the session court after filing of the charge. So two persons were ready to become an approver. So we examined those two persons in the trial and they diverged the entire criminal conspiracy. Now, law of approver says that he's a self-confessed traitor. Therefore, law says that approver evidence must be corroborated in material aspect. Kindly see, the illustration to 114 of Indian Evidence Act says that approver is unworthy of credit and conviction will not proceed unless it is corroborated. Whereas the section 133 of the Evidence Act says that approver is a competent witness and uncorroborated testimony can become the basis of the conviction. So there are two different provisions in the Indian Evidence Act. At one hand, it says that yes, there must be corroboration. Whereas on the other hand, it says the corroboration is not required. So in short, rule of law requires that approver evidence, even evidence, uncorroborated testimony can become the basis. But rule of prudence requires that it must be corroborated in material aspect. So in short, the prosecution has to satisfy the court that this is the attending corroborative material which confirms that whatever the approver is telling, the truth and nothing the truth and all of the truth. So in this way, we marshal the evidence in the bomb blast case. I need not go the details of the case, but we established that a criminal conspiracy was hatched in Dubai, and in pursuance of the criminal conspiracy, these accused persons had conspired to damage Bombay city, to blast Mumbai city, and accordingly, on 12th March 93, at one and the same time, there was a series of the bomb blasts at 12 places, and whole country was shocked by the said bomb blast. The another document which I found about the passport of such persons who had participated in the conspiratorial meeting at Dubai. When I had seen those passports, what I would like to emphasize to my young friends, while conducting a criminal trial, one has to peruse all the investigation papers, whether he is a public prosecutor or whether he is a defense counsel. Mr. Aniket will explain you very nicely on that aspect. But if you peruse the investigation papers, then you will find whether there is a connecting and corroborating evidence. Now, naturally, you see, how to deal with the evidence, that is an again very important factor. Now, Section 3 of the Indian Evidence Act says, a fact is said to be proved when it's reasonable. I would like to exactly quote the section. A fact is said to be proved when, after considering the matter before state court, either believes to exist or consider its existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it exists. Kindly remember, my friends, the beauty of Section 3 of the Indian Evidence Act, and I would like to emphasize, a prudent man ought to believe. This clearly means law believes in the common sense of a common man. The question that shall have to be asked, even I argue at this point in the court of law, that whether a particular statement would be made by a witness would be found trustworthy by a common man. See, ultimately, you see, the court is not a witness to any incident. The prosecutor has to put the facts as brought on record by the investigating agency. Defense counsel cross-examine the witness in order to establish that such evidence of the witness should not be believed, but he is a discredited, he is caught up witness, he is a chance witness, and therefore his evidence should not be believed and his client should be acquitted. That is the line of the defense argument. And the real question and the ticklish question before the court is how particular witness to be believed or disbelieved. Mr. Aniket will explain you about the omissions, contradiction, about the art of cross-examination, etc., etc. But the real moot question before the court is how court should assess the evidence of a particular witness when the court is not a party to any incident or incident in question. Then my simple submission that if a common man is likely to believe a particular thing, see, one has to ask this question to ourselves. If a common man is likely to believe a particular thing, then it has got to be accepted. If a common man does not believe a particular thing, then it has got to be rejected. The court cannot be non-informative about the things which happen around the time. So this is the important question. See, in a lighter note, I would say, what is happening nowadays and what we are seeing and reading in the newspaper in respect of the Sushant Singh's death. See, media has taken a stand that it's not a case of a suicide, but it's a case of a strangulation. A common man is likely puzzled whether Sushant Singh has committed suicide or whether he has been murdered. I will deal that aspect in respect of the circumstantial evidence. But therefore, what I would like to emphasize that in the serial bomb blast case of 93, when I was dealing that aspect about the passports of the people who had attended the conspiratorial meeting in Dubai. And when I perused the passport, I found that there are the 7 persons who had attended that meeting. Dawood Ibrahim, Tiger Memon, they never came back. So Mumbai police was not in position to apprehend those persons and to seize their passport. But Mumbai police has apprehended 7 to 8 persons who had been in that meeting of conspiratorial meeting and whose passports were seized. When I perused the passport, I found that on the passport, there was a specific entry of disembarkation. That is when the date and time when they left Dubai airport. Again, after 15 days, there was another entry, embarkation entry, that is the arrival of those people on Dubai. According to the international rules and regulation, if any person, any citizen leaves the country, the immigration authority makes an endorsement on the passport. So these 7 people have specific entry of immigration authority of Dubai about departure from Dubai on a particular date. And after 15 days, there was another entry endorsement about their arrival in Dubai. The question that would arise, which country these people had visited? Kindly see, all accused have retracted the confession. That is 7%. And there is no explanation forthcoming on the record. It's a simple thing. अगर उनकी एंट्री पासपोर्ट में नहीं है, जिस कंट्री में गए, इसका मतलब ये तो नहीं कि वो हवा में उड़ रहे थे. They were not flying in the air. So 7 people must have visited such country, and that country must have taken abundant precaution to avoid their entry on the passport. So that country has avoided to endorse the arrival and departure country on the passport of these 7 persons. Why? See, ultimately, what is meant by law? It's a codified logic. Dear friends, we have to develop and cultivate our mind in such a manner that always we should think why the legislature have made this provision. What is the object and reason behind this particular provision? Why the legislature had an intention to enact a particular act? If we cultivate this habit to train our mind, then you will get answer. Jurisprudence is a Bible of law. Jurisprudence teaches us as to what is the purpose of a particular provision, why the punishment is been prescribed, what are the sentences, what are the kinds of the sentences, what is the purpose of a deterrent sentence. Deterrent sentence is only not to punish the very criminal, but to give a strong message to the like-minded people in the society. So in a way, so you have to train your mind to think over. You see, when I joined the law, to be very honest with you, and later not, I must confess at the juncture, Mr. Nikam, that I was not very keen to join this legal profession. But my father had a strong desire that I should become a lawyer. Initially, I started my practice in the cooperative law for about a year. Then I thought that this is a very small field. Then I was in dilemma whether to practice on civil side or criminal side. Both sides are very good. But I thought that a common man is rather scared of criminal. And therefore I decided to appear throughout my life against the criminal. And that is the reason as to why I'm working as a special public prosecutor since last number of years. I never accepted any brief on behalf of the criminal. My son is a very good lawyer. Of course, I need not praise him. But at the same time, I'm proud to say that Aniket also developed that habit of cultivating his mind, how to think over a particular aspect. So what I was telling my friends, that when I perused the passport, a very legitimate query that arose in my mind as to why that particular country has avoided its name on that passport. And therefore, there is some reference, though retracted confession also can form the basis of conviction, that is the law says. But confession must be corroborated. Retracted confession must be corroborated. And that is the reason. You see, the burden of proof. Normally, it is for the prosecution to discharge the burden. But under certain circumstances, it is for the accused to explain certain things if any particular special fact is within its knowledge in view of the provisions of Section 106 of the Indian Evidence Act. Once I convinced the court, look, sir, these people are having this passport. There is an endorsement of disembarkation and embarkation, of leaving Dubai, arriving in Dubai on particular day. But where these people had gone, that country has avoided its identity. And therefore, it is for these people, 7 people, to explain as to where they have gone. If they won't explain, because this is a special fact within their knowledge, if they won't explain, the legitimate inference would be they had gone to such a place which they have mentioned in their confession, though it is retracted, that is the Pakistan. See, ultimately, this argument was upheld by the court, and we established that they had gone to Pakistan with the help of the certain Pakistani people. Immigration authorities have avoided the name of their country, etc., etc. That is the Falana issue. So, what I would like to emphasize, while conducting any criminal trial, either as a prosecutor or a defense counsel, you have to be very keen and particular in reading all the investigation papers. Then you have to set up a defense. What is to be proved? As a defense counsel, you have to see how to particular witness is to be grilled by cross-examining. Effective cross-examination is the most important thing. How to witness to be discredited? Why should be disbelieved? That is how you have to develop your line of defense as well as the line of prosecution in marshalling the evidence. You see, it is very easy if there are the eyewitnesses. People say like that. But I would say that if the case rests on the circumstantial evidence, then matter is entirely different. Now, while coming to the present matter, Sushant Singh's death case is concerned, there are no eyewitnesses in this matter. The entire case rests on the circumstantial evidence. Now, I'm not dealing this case, of course. I'm just academically, I'm discussing the case before you. Sushant Singh was found dead in his flat on 14th June. There were certain persons were in the flat, and they found the Sushant Singh's dead body. Sushant Singh was hanging, that is what they say. Now, see, ultimately, when the case rests on the circumstantial evidence, the investigating agency will require to find out, to connect the accused if at all there is a case of an homicidal death. So now the most debate is whether it is a suicide or it is a homicidal death. Of course, the investigation is at a crucial stage. So I won't divulge much things on this case and will not discuss also, because I don't want in any way the investigation should be influenced by our discussion. So as keep it as I would like to deal only with the basic principles of the circumstantial law. Now, it is settled law that evidence in the nature of the circumstances is as important as that of an eyewitness. Why? What is the jurisprudence behind it? There are certain famous maxims in the criminal jurisprudence. The first maxim is human being may tell lie, but circumstances do not. Human being may be motivated, but circumstances do not. Circumstances are always contemporary with the incident in any incident in question. What these maxims indicate, dear friends, they indicate that nobody can change the circumstances in the past. And therefore, I would say, person can control the present, person can control the future, but a person can never control the past. Now, the legitimate question that would arise in our mind, where from does this term circumstantial evidence comes? Friends, kindly remember, Section 3 of the Indian Evidence Act does not define the term circumstantial evidence. Obviously, the term circumstantial evidence came into existence by law of precedent. The law of precedent says that the term circumstantial evidence means such circumstances or facts of the past on the basis of which the court can draw an irresistible inference. The famous dictum in the criminal law that evidence is not to be only compatible with the guilt of the accused, but it has got to be incompatible with the innocence of the accused. It means the circumstances which are brought on the record by the prosecution and duly proved must constitute the chain of circumstances. This is the most important thing. So the duty of the prosecution is to place on record to prove such chain of circumstances which would connect the accused with the crime. In short, the circumstances must be such that the only possible, reasonable, logical, and irresistible inference would be that the offense is committed by the accused and accused alone. Now, how one can draw an irresistible inference? You see, inference, there is a difference between inference and irresistible inference. Law appreciates the irresistible inference. If there is an irresistible inference that the accused has committed a crime, law can accept the crime. It is called in the logic, that is syllogism in logic, how to draw an irresistible inference. The syllogism in logic says, जिसको तर्कशास्त्र का प्रमेय कहा जाता है, उस तर्कशास्त्र का प्रमेय के सिद्धांत अनुसार all men are mortal, all kings are men, therefore all kings are mortal. This is the third equation inference that was derived, is that all kings are mortal, which is arrived from the truthfulness of the earlier two propositions, that all men are mortal, all kings are men, and therefore all kings are mortal. So we have to develop that thinking process, how one can draw irresistible inference by effective cross-examination, bringing such material on the record wherefrom you can convince the court, you can convince the judge that, sir, this is the only reasonable and irresistible inference can be drawn. And that is the why, when the case rests on the circumstantial evidence, it is the most important thing. Now, see, the another case which I had dealt with, the terror attack of 26th November. I have conducted many high-profile cases in Maharashtra, including the Gulshan Kumar murder case, the terror attack of 26th November and Pramod Mahajan murder case, and so many other blast case, terrorist case, and the gang rape, and etc., etc. But while dealing with the case of a terror attack of 26th November, you know, on the night of 26th November, 10 terrorists came from Pakistan, and only there was one lone surviving terrorist was found, that is Ajmal Amir Kasam. See, that is the biggest challenge before me, how to conclude this trial within the shortest possible time. The serial bomb blast case took about 12 years, and the government was thinking that this case will also take a long time because there are the number of the witnesses in the terror attack of 26th November. And therefore, after seeing the case, in a criminal trial, there is one provision, opening of the case by the public prosecutor. Section 226 deals with, 220 or 221 or 223, I don't recollect exactly, section 223 might be in that one. Public prosecutor has to open his case by describing the charge brought again and by describing the evidence. When I opened the case, I found that there the police have examined about 700 or 800 witnesses. The judge naturally asked me query, well, Mr. Nikam, when you are going to conclude this trial, what is your approximate timetable for completing the trial? I told the judge, sir, as far as possible, I will take the shortest time because I know there's a lot of expectation of the people. The justice must be done and our justice should be transparent. No person should get an idea that we have something rather harsh on him. And even Ajmal Amir Kasab, though Pakistani, will see that proper legal aid will be provided to him. That was an assurance by me to the court. But at the same time, I say, sir, I would like to recourse to the provisions of section 296 of Crpc, that is tendering evidence on affidavit. Naturally, the judge asked me, section 296 permits the prosecution to tender the evidence by an affidavit of a formal character witness. What is the formal character? That is not be defined in law. So I laid down certain guidelines, principles in the court. I say these are the formal character witnesses. I will file the affidavit of those witnesses and I will call upon the defense to cross-examine if at all they would like to cross-examine. In this manner, I completed trial. For the shorter time, I need not go in detail of this case, but how witness, this is the prosecution side. I have explained how prosecutor has to build up the case. I am sure Mr. Chadha, Mr. Aniket will try to demolish prosecution case by explaining you to what are the principles behind the cross-examination, what are the guidelines, what is the principle and what is the object of the guidelines. So Mr. Aniket, this is now over to you.
Hello.
Before Aniket ji takes over, it was so nicely you have summarized the entire scenario from the point of view of a public prosecutor, how he has to build the case. And now, though it's not a challenge at all, but let us see how, of course, we want to know what are the, intricacies of the cross-examination and how the defense has to build the case. And we are, greatly honored to have you, Aniket, today with sir. And thank you very much, sir. It was really enlightening. And 1 minute bhi dhyan hat nahi raha tha usse. So grateful to you. And I am seeing the messages which we are receiving on YouTube are immense. We have already, more than 1,000 plus messages have already come.
Okay, thank you. Thank you. Thank you.
Grateful to you, sir.
Thank you.
It is your turn now.
Ji. It's a very heavy mantle of responsibility to discharge. Let me begin this by saying Adarniya Nikam sir, Adarniya Chadha sahab, Adarniya Verma sahab, and all the viewers who are watching and hearing us today, a very warm good afternoon to each of you, or rather good evening to each of you. Well, in the beginning itself, Nikam sir said that as a prosecutor and me as a defense lawyer, we always maintain that independence and that line of difference where we ensure that we don't encroach upon each other's jurisdiction. But at home, those lines get a little blurred. And I'll tell you why. At home, normally my father, who practices as a prosecutor in his professional life, and I as a defense lawyer in my professional life, but at home, Chadha Sahab, what happens is, I am the one who presses charge against my father on behalf of my mother, and my wife acts as a defense lawyer pleading on behalf of my father. And the only defense witness that my father gets all the time is my 3-year-old son. And we see to it that at home justice is not only done, but it is seen to be done. Keeping aside the humor aspect, well, I have always learned watching him since I was a child. Though my father never wanted to become a lawyer in the first place, on the contrary, I always wanted to be in this profession and in this field. When I watched him while he was performing on the field, and that has always inspired me to be into this profession. Well, today I'm going to speak, since I practice on the defense side quintessentially, today I'm going to speak about the different angles that a defense lawyer must keep in mind while undertaking a trial or while defending his client who is accused of some offense. And while doing this, I will be speaking about cross-examination, the niceties of cross-examination, the importance of suggestion that one should put at the end of the cross-examination, and the stark difference between murder and culpable homicide not amounting to murder, because it's a very important distinction that we must understand. And I'll share with me the experiences that I've garnered so far. Satyam, Shivam, Sundaram are the 3 beautiful aspects of human life. And they say that these are the gifts of nature or divine given to a person. Sundaram reflects on the face of an innocent child. Shivam is the gift given to the human mind. And truth is naturally placed in his mouth. It is common knowledge that truth comes out quite naturally from the mouth of a person, while falsehood is an artificial thing concocted by a person for one reason or the other. Law believes in all these natural tendencies of the person. But at the same time, law further knows that person may be tempted to tell a lie for one reason or the other. Perhaps it could be for one's own benefit, or to suppress something, or to cover up something, or it could be out of revenge or any mala fide motive, which are the primary reasons why anybody would lie. Bluffing, as they say, may be an art with certain persons, but when it comes to the question of evidence, then naturally it has its own serious effects. And to overcome this possibility of a person making intentionally a false statement on oath, our legal system, which I consider to be an extremely mature legal system, provides that every witness who is under oath shall be cross-examined by the adverse party in order to establish the truthfulness or otherwise of his deposition. It is believed that an expert cross-examiner can very well expose the falsity in the evidence given by a particular witness. Well, though it is true to say that an advocate do not really monopolize the whole wisdom in our world, yet advocates have a trained mind to expose the falsity of a witness's testimony. And therefore, in any criminal trial, it is very important, my dear friends, to understand the basics of cross-examination. Well, it is said that lawyers are very interesting people. They write a 10,000 word document and still call it a brief. And today, I'll be as brief as possible because I know I don't want to encroach upon your Sunday evening time. It is said, he who knows the skill of cross-examination knows the art of advocacy. And of all the accomplishments as an advocate, cross-examination is most useful, but at the same time most difficult to acquire. There is no single formula or any precise mathematical proposition about how to conduct cross-examination. It is an art which has to be acquired by experience, determination, practice, and hard work. Cross-examination, my friends, is one of the greatest weapons to test the veracity of a witness when he is standing in the witness box. I would rather say cross-examination is a sword of attack and also a shield of defense. And it is also very, very rare to come across testimony of a witness which does not have an embroidery of untruth to it. And it is a job of a fine cross-examiner to separate the grain from the chaff. Before I really deal with the wisdom of cross-examination, let me address on the relevant provisions of law under the Evidence Act, which deals with the provisions of examination of witnesses. As we all know, that examination of witnesses falls in Chapter 10 of the Evidence Act. And it is therefore very essential that before we actually cross-examine a witness, we know these basics, what is there in our Evidence Act. If we read Section 137 of the Evidence Act, it provides that there shall be examination in chief, which means the examination of a witness by the party who calls him. Then Section 137 of the Evidence Act defines cross-examination means examination of a witness by the adverse party. And the very same section defines re-examination means examination of a witness subsequent to the cross-examination by the party who calls him. If we see Section 138 of the Evidence Act, it provides the order of examination of witnesses, which naturally means that a witness has to be examined in chief first, then will follow the cross-examination, and thereafter it need be the prosecution may call that witness for re-examination if he is given certain admissions which are really hurting the case of prosecution. Now it is important to note that the examination in chief must always relate to the relevant facts. But the cross-examination need not be confined to the facts which were stated by the witness in his examination in chief. And the simple reason behind this is that for cross-examination to be effective, it need not be restricted to what the witness has said in his examination in chief. And the cross-examiner may ask other questions also in order to discredit or impeach the credibility of that particular witness. Because in order to shake the version of that witness, a cross-examiner may have to, ask a lot of other questions which would reflect on the conduct of that witness, which would reflect on the state of mind of that witness, which would reflect on the demeanor of that witness. Supreme Court in the famous judgment of Vadivalu Thevar versus State of Madras had held that witnesses can be classified primarily into three categories: wholly reliable, wholly unreliable, neither wholly reliable nor wholly unreliable. And as a cross-examiner and as a defense lawyer, our endeavor should be to bring a witness in the category of either wholly unreliable or neither wholly reliable nor wholly unreliable. If the witness is neither wholly unreliable or wholly unreliable, then the court will have to be circumspect, cautious while accepting the testimony of such witness, and ideally his testimony can be accepted in courts of law only if there is sufficient corroboration in material particulars. The test therefore is, and as Nikam sir had rightly pointed out, the simple test is whether the evidence tendered by the witness while being under the oath appeals to the reason of a prudent man. And by this I mean whether the story tendered by the witness is natural and probable, whether it is supported by different circumstances, including subsequent conduct of the persons concerned. So therefore, my friends, it is very important to understand that in order to inspire the confidence of court, the evidence of the witness must be such that it should test the reasoning of a prudent man. And if it is not doing so, then perhaps one can say that this witness is either not believable or this witness is lying, and this witness therefore should not be accepted. The deposition of that witness should not be accepted. And therefore the cross-examiner has to cross-examine the witness in such a manner that the court must feel that the fact deposed by that witness does not exist at all. It is therefore very essential that when we undertake cross-examination, to have a holistic view of a matter. Taking the example of Sushant Singh Rajput's case, Mr. Nikam sir had cited this instance, and let me take it a little ahead. We have seen the way several persons who are involved with this case, the flatmates of Sushant Singh Rajput and other persons who were acquainted with Sushant Singh Rajput, going on television channels and giving several interviews explaining their side of the story, knowing that their statements are already recorded by the investigating agency. And suppose tomorrow this case is put to trial, whether it is for trial of abetment to suicide or trial of murder, I do not know. We do not know. The charge sheet has not been filed so far. But when this case is put to trial, the defense lawyer in that situation, if those witnesses come in the witness box, would have to just pull out all the statements that these witnesses have made to different media channels and confront them with that. Confront those witnesses with those statements that they had given to the media, in order perhaps to shake either the credibility of that witness or to point out the way this witness has been changing his stance, the way a chameleon changes his colors. And perhaps therefore this witness is not believable in the eyes of law. And therefore, as I said earlier, a criminal lawyer, I mean, I would not say a criminal lawyer, a lawyer who practices on the criminal side, because criminal lawyer may also mean that somebody who's done a crime and is practicing law. So I don't like that kind of classification as a criminal lawyer, but a lawyer who practices on the criminal side has to therefore be extremely vigilant, open-minded and has to understand the far-reaching consequences of a particular case. And in order to discredit a witness, to shake a credibility of a witness, to impeach his credibility, cross-examination is the most effective tool that the law has bestowed upon a defense lawyer. There are a few rules that I think one must keep in mind, which I have learned from little experience that I have as a defense lawyer, which one must keep in mind while one undertakes the exercise of cross-examination. Rule number 1, a cross-examiner must always maintain a constant eye contact with the witness. I think there is some video problem.
No.
Okay.
Carry on.
Okay.
It's absolutely fine.
Okay. I'm sorry. So rule number 1, a cross-examiner must always maintain a constant eye contact with the witness. If we stare into the eyes of a witness, we can very well understand and comprehend what is passing in his mind. The anger, the frustration, the truth, the falsehood, the anxiety, all could be noticed in his eyes. And for that, you need not do any particular yog kriya. It is only experience that will teach you to read the eyes of your witness. Apart from looking into the eyes of a witness, we must also keep a close watch on his body language, on his voice, because it will help us to ascertain the mental state of that witness. If we observe the body language of a witness, we will come to know that if a witness is constantly looking at his lawyer, probably if it is a prosecution witness looking at the prosecutor after every sentence that he utters, you know perhaps this witness is trained by the concerned prosecutor, and you know that this witness is a tutored witness, and you know what is to be done next. So always keep a close watch on his voice, on his body language, look into his eyes and understand what is passing in his mind. Rule number 2, one should always be mild with a mild witness. One should always be stern with a stern witness. One should be shrewd with a crafty witness. That's rule number 2. Rule number 3, a good cross-examiner should never threaten the witness or intimidate a witness, as that will not go well with the courts also. Because as a lawyer, we have to maintain the decorum. We are the officers of the court first, and therefore we should not yell at a witness, raise our voice at a witness, try to scare him off, intimidate him. Often I have seen lawyers losing their temper or patience while cross-examining a witness, which results into lawyers becoming aggressive. I believe that we must never lose our self-control, our poise, our composure while cross-examining a witness. We must always maintain our dignity as a lawyer, and we should not get into a verbal spat with our witness. Rule number 4, we must determine the order in which a witness is to be cross-examined. Well, witnesses usually come prepared with the sequence of events narrated in his examination in chief. And if you're facing Senior Nikam sir in a trial, when he is the prosecutor, let me tell you an inside scoop, because that is what they usually now these days call, whenever there is a breaking story, they call it as an inside scoop. You have to be very careful with the witness. And in order to break his line of thought, you have to dislodge him by changing the sequence of events in terms of asking the questions to him. Because that witness is well prepared. He knows what he has to answer. He knows he is going to face a tough defense lawyer. So he is prepared himself. So in order to dislodge him and to take him by surprise, the cross-examiner must change the chronology of questioning. Rule number 5, we must put questions to the witness in such a way that he would not get an idea as to the real objective of our cross-examination. As far as possible, I believe we must try to fix the mind of a witness far away from the main topic at which our questions are directed. If we are desirous of getting a particular answer to a particular question, don't put that question directly to that witness. He will be cautioned. He will understand what is there in your mind. A series of questions, each leading up to the point, will get the job done. And once you get your answer that you want, leave it there. Don't further fiddle it. Don't further again poke him and again get into the same issue, because the admission that you have got may then get whittled away. So therefore, be very careful in terms of cross-examining a witness so that he does not understand the real objective of your questioning. Rule number 6, our face, no matter how smart you may look, no matter how handsome you may look, no matter how beautiful you may look, but our face should not be the mirror of our emotions. We should not express joy when we get a favorable answer, nor we should express frustration, anger, anxiety when we don't get a favorable answer. Always maintain a straight face, because always remember, witness is also a human being. The way you are reading his eyes, he is also trying to read you and your eyes and your body language. So never ever let it come on our face as to what is passing in our mind. Otherwise, the trick that we are going to, the trick that we know of reading his body language is something that even he can understand and read your body language and understand what is your line of thought. So never let your face be the mirror of your emotions. Rule number 7, it is very important to study the witness from a human perspective and understand the psychology of the witness. Before a witness really steps into the witness box, we have to read his statement which he has given before the police under 161. Understand that witness, understand him, try to get into his shoes, understand his psychology as to what his psychology would be if he was an eyewitness and actually witnessed that incident the way he's narrating it to be, and then cross-examine that witness. And that is how you will be able to dislodge that particular witness. Let me share with you a piece, or rather a case where a cross-examination was conducted in such a manner that it resulted into an acquittal. There was this agriculturist who was charged with the offense of murder, of killing his own 11 years old daughter. She was killed in his own agricultural field. There was some dispute between him and his daughter. He threw her on a stone, no intention, threw her on pushed her rather. She bumped off on that stone that was lying there on her head, and she died instantly because of the fracture. 11 years old. After this incident, his wife left him. And when this incident occurred in his agricultural field, there was his other child, an 8 years old boy who was present there, the sole eyewitness to that incident. The man was charged for the offense of murder. And the only eyewitness was that his own son, and who was not going to support him because the wife had deserted that man and the son was with the wife. Charge sheet was filed, the trial began. Now it is very important as a defense lawyer that we actually visit the scene of offense before cross-examining a particular witness in order to know the scene of the offense, the topography of that area, and to actually construct the scene in your mind to understand what could have happened, what would have happened, what might have happened. So the cross-examiner must inspect the scene of offense in order to understand all these things. And when this cross-examiner inspected the scene of offense, he realized that near that agricultural field, near that scene of offense, at some distance, there was a lake. But the lake was positioned in such a manner that if you go to the lake, you cannot see the scene of offense, because the scene of offense, that agricultural field, was at some height topographically. The incident had occurred at between 5 to 5:30 in the evening. When the lawyer goes near the lake at around the same time when the incident had occurred, he saw that several young boys between 8 to 12 were swimming in that lake. And he also saw that when he's standing near the lake, he could not see the scene of offense. So he
Sorry, Aniket.
Yes, sir.
Mr. Chadha.
Yes, sir. Yes, sir.
I had to attend one other conference. So can I leave if you don't permit, if you permit me, Mr.
So grateful to you, sir. Though we
Thank
have a
you.
lot of questions, but
Yeah.
thankful to you.
I will engage Mr. Aniket as my advocate to respond
Yes.
all your questions. Okay. Thank you,
Okay.
Mr. Chadha.
Thank you so much, sir. Thank
And
you so
best
much.
of luck
really-
to all students. Thank you.
Thank you very much, and I'm really very grateful to you.
Thank you.
We will,
Thank you.
We will have another time when we will
Yeah.
have questions.
Thank you. Thank you. Thank you.
Thank
Bye.
you, sir.
Bye.
Thank you, sir. Thank you.
Thank you, sir.
Thank you.
Thank you. Yes, Aniket ji.
Yes.
We are really all of my students as well as other lawyers, dignitaries who are here. They are continuously sending me the way you have explained the rules of cross-examination. You know, even I am learning today. Very
No,
nice.
my pleasure.
Thank
sir.
you very much.
It is all that I have learned from my father. So it was
He is-
so I am thankful to you to make me speak in front of him. Though we ensure that we are never in the same court. But thank you again.
No.
Yes.
It's
So
a
may I?
pleasure for us. Please
Yes.
do.
Yes. May I continue? Yes. Thank you. So friends, what I was telling you is about this case. So when this lawyer went to this lake, he realized that the scene of offense could not be seen because that scene of offense, that agricultural field, is at some height. Now the charge sheet was filed, the charge was framed, the man was put for trial for offense of murder of his own 11 years daughter. The case was very watertight because the witness, the only sole eyewitness, was his own son, who was hostile to this man, to the accused, because he saw that he pushed his sister and she died because of the injury that she sustained. Now it was natural that the boy was not going to support the father. And when the examination in chief happened, the boy said the way incident occurred, narrated the entire incident, that he pushed her and then she died, etc., etc. Now when the lawyer for the man stood up, and please see why I'm telling you this is that we have to understand the psychology of the witness. Now in this case, we have to understand the child psychology. And the lawyer had visited the scene of offense. He knew what he had seen there. He had constructed the scene of offense in his mind. So the lawyer, the defense lawyer, started asking usual questions at the initial cross-examination. And then he came to the scene of offense and the topography of that place. And he asked that child, and these were his questions. These were his questions. Well, look, is it correct to say that near that scene of offense, near your agricultural field, there is a lake at some distance? To which the boy said yes. Then the cross-examiner said, is it also correct that around 5 to 5:30 when this incident had occurred, at the same time, many young boys of your age every day go there for swimming. They have a lot of fun. They enjoy splashing the water, playing some games in the lake. Don't you know swimming? Please understand. So the lawyer explained to him what the boys do, the fun that they have, and then he asked him, don't you know swimming? He was an 8 years old boy. Had he said he doesn't know swimming, he would have perhaps been understood as a timid boy, because in the village, because this incident had occurred in a village, if you are not doing what others are doing, perhaps you are, put in the bracket of being timid or being incompetent. So he readily said, no, I do know swimming. Of course I know swimming. Then the lawyer said, oh, very good. Good. You seem to be a brave boy. Then the lawyer said, these boys have so much fun every day. Don't they allow you to swim? Don't they allow you to swim with them? Again, see, this was a tricky question. And again, this was playing on the psychology of child. He did not want to be somebody who's been isolated from his peer group. He said, no, we all are friends. Every day we go swimming. Then the lawyer changed the topic. He said, is it correct to say? And he said, I visited that scene of offense. When I stand there, I cannot see your agricultural field and the tree where the incident occurred. The boy says, yes, it cannot be seen. It is at some height. The lawyer said, okay. Then 2-3 random questions he asked. And then again, he went back to the same swimming theory. He said, on that very day, you were also swimming as usual with all your friends, splashing water, having fun, enjoying the water in the lake. And there was a smile on the face of that lawyer. And again, you have to maintain that gentle smile when you are cross-examining a gentle witness. And the boy was now confident that he knows swimming, He's somebody who is accepted by his peers. He goes there, and when the lawyer asks him that on that day also you were swimming, having fun, etc., etc., and the boy says, yes, of course, even on that day, at that time, I was swimming along with my friends and we had so much of fun. That's it. The lawyer stopped there. He didn't ask anything else apart from other than that, and he started asking some random irrelevant questions. The public prosecutor was a very smart man. He got it that the boy has given a certain dangerous admission over there, that on that very day he was in that lake, and if he was in that lake, he could not witness the incident because the place of incident could not be seen from that lake. So the lawyer wanted to re-examine this witness, and he tried his level best. The prosecutor, he wanted to re-examine this witness, and he tried his level best, to tell him that he is actually the one who witnessed the incident, as he said to the police during investigation and as he said on oath while he was deposing before the court. But this boy, and understanding his psychology, he was so fixated on being in that lake on that day that no matter how hard that prosecutor tried, that boy was not willing to step out of that lake. And the man was acquitted. And this is a true story, my friends. The man was acquitted. So this is the beauty of a cross-examination. And as a cross-examiner, it is very important we understand the psychology of our witness who is standing in front of us. We step ourselves into the shoes of that witness when we are cross-examining him. And unless we do that, we cannot really see what the witness has seen. We cannot think what the witness has thought. And we cannot imagine or anticipate what the witness is going to say. And that is the extremely important knack, I would say, of the art of cross-examination. Well, with this, I've spoken a little bit of cross-examination. I know we have constraint of time. Once the cross-examination is over, a cross-examiner also has to put suggestion to the witness, which is an extremely important part of the cross-examination. Because in suggestion, you sum up your case and you put to that witness. The witness may deny it, but you have to put your case to the witness in the suggestion, because if you do not do it, then that is something that goes against you, and I'll rely upon a Supreme Court judgment in support of that. Well, the term suggestion has its own value and importance while recording evidence in criminal trial. Let me tell you, my friends, the Evidence Act nowhere contemplates the term suggestion. As I said earlier, suggestion means putting up the story by one party to the witness of other party. Thus, accused is putting his defense or his case to the prosecution witness by way of a suggestion. A suggestion indicates the defense of the accused, and while putting the suggestion, the defense lawyer has to ensure that the suggestion is not pregnant with an incriminating fact. Otherwise, the fact in that suggestion stands impliedly admitted. For example, suppose I'll give you another example. In a case of murder, where the allegation is that your client who's holding a sword in his hand and he assaulted by sword, and all the injuries that the deceased has sustained are in the nature of contusion wounds, which could not be caused by a sword, because ideally a sword is a sharp-edged weapon which would cause incised wounds but not contused wounds. And the case is that you were holding a sword. So you do a fantastic cross-examination. You bring on record that how it is improbable that your client was even present on the scene of offense. And after the end of it, you put a suggestion to the witness and you say, look, I say that my client so-and-so was not holding sword in his hand on the date of incident, and this is your false allegation. The witness will say, no, he was holding a sword, etc., etc. But the problem with this suggestion is that you have impliedly admitted your presence at the scene of offense. The moment you say that your client was not holding sword on the scene at the scene of offense. So you cannot put a suggestion which is implied with some suggestion, which is implied with some fact. And if you subtract that suggestion from the fact stands proved. And therefore it is very important that your suggestion should not be pregnant with a fact which is incriminating in nature. So always remember, my dear friends, young lawyers out there, when you put your case by way of a suggestion, ensure that you do not negate the fantastic admissions that you have got in your cross-examination. Always, always, always keep that in mind. With this, let me, as I said earlier, refer to a Supreme Court judgment. In the case of Sarwan Singh versus State of Punjab, which is a 2000 Supreme Court judgment, it was observed that whenever the opponent declines to avail himself the opportunity to put his case in cross-examination, it must follow that the evidence tendered on that issue ought to be accepted. And therefore, it is very important as a defense lawyer to put suggestions at the end of your cross-examination. But at the same time, we have to be extremely careful in putting suggestions to the witnesses, because our mistake in framing, couching our sentence properly, putting that suggestion in a particular manner may damage our case to a great extent. So therefore, cross-examination at the end of its suggestion, ensure that that suggestion is not pregnant with an incriminating fact, so that you do not, overshadow the observations that the admissions that you've got in your cross-examination. Now, let me with this proceed further to the last leg of my of my talk today. Well, try and address on the subtle but important difference between murder and culpable homicide not amounting to murder. Every murder is culpable homicide, but not every culpable homicide is a murder. Speaking generally, culpable homicide without special characteristics of murder is culpable homicide not amounting to murder. The IPC, Indian Penal Code, practically recognizes 3 degrees of culpable homicide. The first is what may be called as murder, which is defined under section 300 of our IPC. The second may be culpable homicide of the 2nd degree. This is punishable under the first part of section 304. And the third is culpable homicide of the 3rd degree, which is defined under the 2nd part of section 304 of the IPC. And even the sentence varies. If we see the sentence in all these sections, it varies, whether it is 1st degree, 2nd degree, or 3rd degree. The distinction between murder and culpable homicide is extremely fine, but a real one. And even, as I said earlier, the punishment greatly varies from each other. Section 299 and section 300 of IPC really speaks about the distinction. And I would not quote the section. I don't want to be too technical. But if we read the 5 sections to section 300 of IPC, then as a defense lawyer, to bring the case from murder to culpable homicide not amounting to murder, while cross-examining your witness, we must keep following things in our mind. And therefore, the distinction is very important. Number one, what was the nature of the weapon used and what side of weapon was used? For example, it is the case of prosecution that we assaulted by a sword. We, in the sense, the client assaulted, your client assaulted by a sword. Now, it is very important to see which side of that sword was used in order to mount that assault. Was it the sharp side of the sword or was it the blunt side of the sword? If it was the blunt side of the sword, then was he really having an intent to commit an offense of murder? Because if he really was having that intention, he would have used the sharp side of the sword. Therefore, it is very important to understand the nature of weapon and what side of weapon was used. Sharp side, blunt side, the kind of weapon. Second, whether the weapon was carried by the accused or was it picked up from the picked up from the spot itself? And this goes to show whether the act was premeditated, whether there was a pre-design, whether there was a conspiracy, there was a meeting of minds between these accused persons where they were armed with weapons and then went to the spot and mounted an attack, or they went there and they picked up what was lying there and attacked with that. So this reflects on the state of mind and therefore whether there was an intent to commit murder or not. Thirdly, whether the blow was aimed at a vital part of the body. So suppose he uses a sword but attacks it on his leg or on his hand, and it is a normal knowledge that if you attack somebody on his legs or hands, he may not die. So the intention may not be to kill him. And therefore, what was the part of the body that was attacked? Which vital part of the body was affected by that attack is to be kept in mind. Fourth, what was the amount of force employed in causing injury? So this largely depends upon the nature of injury, the size, the depth, and this can be ascertained from the cross-examination of the doctor, from the post-mortem report, to understand the location of that injury on the body of the deceased, the size of that injury, the nature of that injury, the depth of that injury. And therefore, from this, one can decipher the intent of the aggressor. Fifth, whether the act was done in a sudden fight, a free fight, a sudden fight, or was it a premeditated incident where they had armed and then went. Sixth, whether the incident occurred by chance or whether there was any premeditation. So all these are interconnected. Being armed with a weapon earlier or picking up a weapon from the spot, whether it was a sudden fight or not, whether there was premeditation or not, in order to determine whether there was an intent or not to commit the offense of murder. Rule 7, whether there was any prior enmity or whether deceased was a stranger. So if there was a prior enmity, it could explain the motive, it could explain the anger, it could explain the prior meeting of minds. If the deceased was a stranger, perhaps there was no prior conspiracy, it was a sudden fight. So all these things again are an indications of the intent of the aggressor. 7, whether there was any grave and sudden provocation, and if so, what was the cause for such provocation. In any criminal trial, it is very important to understand if it is a case of murder or not, whether there was provocation from the side of deceased and whether it was grave, sudden, and whether we did not take undue advantage of that provocation and acted in extremely cruel and barbarous manner. So all these are factors which are to be kept in mind in order to understand whether it could fall within the definition of murder or culpable homicide not amounting to murder. Again, whether it was in the heat of passion, whether the person inflicting the injury has taken undue advantage of this situation and has acted in extremely cruel and heinous manner. And lastly, whether there was a single blow or there were multiple blows. I have seen cases, I have argued cases where a man had used a stick to assault somebody and only in one blow the man died. And that man and that accused was charged for the offense of murder. And I had argued successfully that this could not be a case of murder because for all these reasons. And at the most, it could be a case of not amounting to murder, part 1 or part 2. Certainly not part 1, which deals with intention, perhaps part 2. And therefore, it is very essential to understand all these niceties, all these fine differences and nuances in a criminal trial when we are particularly defending somebody whose liberty is at stake. Well, often as a criminal trial, we have that conflict in our mind and in our heart as to how to defend somebody who's been charged with such a grave offense. And when we are confronted with this question, I always remember what Lord Krishna had told Arjun in the battle of Mahabharata, when he was to face his own kith and kin. He said, it is the job of a warrior to fight. Similarly, it is the job of a lawyer to argue his client's case to the best of his abilities within the four corners of law. Being an officer of the court, be always true, faithful, and honest to the court. And that is how we must discharge our duty as a lawyer, to fight for our client to the best of our abilities. It's a wonderful profession. We always learn a new thing every time we appear in court. I am of the opinion, and even my father has always been of this opinion, that for a lawyer is always a student of law for the rest of his life. And we should never think that we know everything about law. Every day teaches a new thing. Every experience tells us something different about a particular case. And we must always be open to understand, grasp, comprehend, absorb all that we learn in order to become a better human being, a better lawyer. And in turn, since lawyers and judiciary is it's one of the estates of our democracy, and therefore in order to make it a vibrant state, we as lawyers have a lot to discharge as a responsible member of the fraternity. And therefore we must take always due care and precaution that due to our conduct, due to our whatever we say, we do not bring disrepute to this great majestic institution. That's all I would say. Thank you very much everybody for giving me a patient hearing. Thank you very much Chadha Saab, Verma Saab, and all those who are watching us today. It's been a sheer pleasure, privilege to speak with all of you, and it was a wonderful experience. Thank you very much.
Thank you, Aniket. It was really wonderful. You are a great and very nice orator, I must say so. And you have summed up the rules of cross-examination, importance of suggestions, and how culpable homicide amounting to murder and murder, the differentiation between the two. And when you are, taking part in the trial, how you have to see that those exceptions which are there, with your own skill, you can put the case into that and save your client. And in the beginning, you had said one thing which I wanted to say on behalf of all the students. You said that you take inspiration from your father. We all take inspiration from him. We all the participants, students, and at this stage, at present, I must have completed 25 years, and we are seeing him. And today also, I take inspiration from him. And at this stage, look, I know previous week he was in Jalgaon, then he had went to Pune, and so on and so forth. I don't want to go into that. And he's a great human being himself, and what he's doing for the nation. We all are really obliged, I must say. So I think, Bhumika, we have a few questions. Students have asked so many. So let us take up 2-3 questions. And the way you have really, the defense side you have explained, as broadly we are saying, but you have covered almost everything very nicely. Those rules of cross-examination and how that suggestion can be, counterproductive to you. That was an amazing experience. And of course, that example of a boy who was very fond of swimming, and because of which the accused was able to, the lawyer's prudence was, he used his prudence, and how he, moved that witness and in his favor. So that's really, I think, that is what is the art. That's how you learn. And, it reminds me also, small incidents I'll tell you. There was again, I have heard it from my senior. There was a murder trial in which, there were about 10 stones were there. The bigger stone which was thrown on the head of the victim was basically, they had numbered it by chalk, 1, 2, 3, 4, 5, and the witness was police witness, and when he has gone there, that chalk thing was removed. So he was remembering only that the stone number 1 was thrown. So when the numbering was redone, the size, this size stone was made stone number 1. So everything went off. So this also happens. A very quick story I have also said. Bhumika, please come up. Aniket ji, let us shoot few questions to him.
Sure, sir. The first question at hand is, as to what all does a trial judge gathers from the demeanor of a witness? And does he actually look into that aspect while considering other aspects?
See, when you are cross-examining a witness, the demeanor of that witness plays a very important role. And if this witness is behaving in a particular manner which creates doubt about his credentials, about his about the truthfulness of what he's saying, then as a cross-examiner, we must always request the recording judge, the trial court judge, to record his demeanor in the deposition itself. because that plays a great role when the matter goes up in appeal. Because appeal court would never be there to see the demeanor of that witness. But if that demeanor is recorded in the deposition, the appeal court will have an occasion to understand what kind of demeanor this witness was having, when this witness is having a demeanor which creates a doubt about what he's saying. So it certainly has got a lot of importance, and as a cross examiner, we must always insist, if we notice a particular demeanor, to be recorded in the deposition.
Similarly, the best of the best example which you gave of Supreme Court judgment, where it was said that 3 types of witnesses are there.
Yes.
So the ultimate objective of a defense counsel should be that he should see that the witness falls in the 3rd category.
That's right.
Yeah. Please, Bhumika.
So moving on with the next question. So in case the police does not file documents along with the charge sheet collected during the investigation from the accused, then what is the remedy available for the same?
See, I'll share you my own example in a case that had appeared, where a man was charged with the offense of murder. There were 10 to 12 people who were charged with the offense of murder. And the man who was killed was a very famous man in Pune. And 10 to 12 persons were charged. Now, my client, whom I was representing, had taken a stand that he was never present at the scene of offense. It's a case of false implication. He was not even there. And even his CDR would show that he was at some place else. The CCTV footage of a particular hospital would show that he had gone there to admit his relative. Police, of course, had not done their job, and they had not collected all this important piece of evidence. So what we did was, we made an application before the trial court asking them to collect this sort of evidence, to get the CDR details, or to permit us to lead evidence. And the trial court allowed us. The trial court, first of all, directed the prosecution to produce the CDR, and also permitted us to lead evidence in respect of our alibi, proof of alibi. We could do that, and because of that, we got a benefit, and the man was released. So if there is a, say, lacuna on part of investigating agency not doing the investigation properly in a particular direction, as a defense lawyer, of course, we have a chance to lead our own evidence, which we could do in a trial. We can also make independent applications at the appropriate stage for the purpose of calling of certain documents which are not there in the charge sheet.
Yes, Bhumika.
Okay, so moving on to the next question. So it states that as a country with strong sentiments and drastic emotional response to heinous crimes, do you think that we are inclined more towards the rights of the alleged victim than the rights of the accused?
No, I don't think. See, by we do not mean judges. By we mean commoners, like citizens. Now, citizens really don't do, they are not involved in the judicial making process. They are not the judges. Judges have got judicially trained mind. They don't get swayed away by all these things. They don't get swayed away by media reports or get emotionally surcharged. They are extremely objective about the case that is there in front of them. So emotionally, a citizen may feel particularly about a particular case, but that does not essentially mean that that is how the judges will look at it. Judges have to look at it from the perspective of the evidence that is before there, and they have got the trained mind to look at it that way. So there's no reason why we should think like that.
So meaning thereby, Aniket, what I put to you a straight question. Don't you think there is any effect on the judges of this media trial? Is there some effect?
See, I'll tell you, there's an old Shakespearean quote: judges are not human beings. They don't live in ivory towers. They have hands, organs, dimensions, as we all human beings have. But having said that, judges, as I said earlier, have got a judicially trained mind. And I recently read a justice, honorable judge, saying that judges have to switch on and switch off. By this I mean that we should not let our prejudices affect a particular case. I have full faith in judiciary. I have full faith in the system that we have. The media trial may have an impact, but it would be at the most a momentary impact.
All right.
Yeah. So of course,
and to add to what you said in a very positive way, the media will talk about the case in the very beginning only, and when the trial, etc., criminal law trial takes,
does not speak.
And at that point of time, nothing.
That's right. Now, if you take Sushant Singh's case, yes, it's been going from one swing to another, from one pendulum to the other, from what to what, and so. But I mean, nobody gets influenced. I mean, common people do get influenced, but then common people do not they do not sit on those chairs to do justice. So,
and the other thing which is very common is we are governed by paper justice. So whichever party means whichever side has strong documentary proof. Documentary in terms of even in criminal cases, the evidence in terms of documents.
That's right.
Recording of witnesses, cross-examination, that is recorded in the paper. So the strong paper will win the cases.
That's right.
Yeah, Bhumika, you have other, and we will also ask Aniket what is his plan. Can you spare another 10 minutes with us?
10, if we could make it little less than 10 minutes.
So last two questions.
Yes, sir. Please. Thank you.
Otherwise, you are also very brief in giving your answer. So 2-3 questions last. Thank you very much, Aniket.
Thank you.
Sir, the next question is as to what are the drawbacks that adversarial system poses in the facilitation of justice in criminal system or trials?
It is only because of this adversarial form of system that we have got a very mature legal system, as I said earlier. Because in adversarial form of system, we have got opportunities to disprove the allegations that are leveled. And in this adversarial system, every accused is presumed to be innocent until proven otherwise. So I don't think there are any drawbacks. If there are any, the drawbacks, it perhaps is the large amount of cases that are, that are pending, not getting disposed of. And even our courts are seized of this issue. They are trying their best, to try and release or ease this burden. But because of the population that we have and the number of cases that get filed daily, it is a difficult job, but we have to build that system. We have to perhaps, improve our infrastructure to deal with these issues.
Yeah.
So posing the last question. So has the reverse burden of proof in India emerged as a trend, which is noticeable in the world of criminal trials nowadays?
So in special acts like POCSO, if we see, there is a reverse burden of proof where the proof is upon the offender. If he is alleged to have committed a particular crime against a particular minor girl, then so this reverse burden of proof is only in respect of special statutes and for special offenses. It is not in respect of every offense that is provided under the penal code. So normally the law is that every accused is presumed to be innocent. However, if there is a particular offense that is committed, then the burden is upon that accused to discharge himself from it. Even if we see section 106 of the Evidence Act, if there is a special fact which is within your special knowledge or domain, it is your burden to explain that fact. For example, in case of the WhatsApp conversation that we have seen of Deepika Padukone in respect of that drug chat, there is a WhatsApp conversation which Deepika Padukone seemed to be engaging with somebody, and they are saying that, do you have this, do you have that? Now the burden of proof is upon her as to why this conversation is in a phone in the first instance. If you are asking about a particular contraband, which is a banned substance under the Narcotics Act, what was the purpose behind it? Was it for the purpose of decorating your house? Was it purpose of giving it to someone? Was it purpose of self-consumption? One doesn't know. So, then in such a situation, the burden of proof lies upon them to explain. Okay?
Yes, sir, absolutely.
So
I think
there are so many other questions, but of course,
we'll save it for some other day.
Yeah, we will have, and I must congratulate you, Aniket. The way you have presented, it was superb, excellent. That shows your hard work. That shows your commitment towards your work. That shows your passion, and that is the reason, I can say today, and we all will be witnessing it. Sky is the limit for you. My good wishes to you.
Thank you, sir.
And of course, great thanks to Nikam sir that he has, accepted our invite. And I'm so deeply thankful to you, Mr. Verma, that today you have taken out time. So grateful to you.
I, at the risk of taking all your times, especially this is, please, if you permit me just 2 minutes, I know Councillor Aniket is in a hurry to leave. I just wanted to say that Councillor Chadha has, been a very, very old friend of mine, and I'm so intrigued by the law. And the reason I'm here, most of you would be wondering that a legal person listening so intently and wanting to participate. Well, besides the fact that I had an engineering company which deals with specialized safety solutions for working at height, I also don the hat of a co-chair for the India Safety Leadership Group of the British Safety Council, where we try and enforce, the compliances are followed, all HSE health safety environment policies are followed. Unfortunately, there is a gross violation of statute compliances. People want to not invest money, or they want high productivity, and so they don't take into cognizance the value of the human life. And so therefore I was intrigued and I wanted to see, understand a bit of the criminal nuances. More than that, I'm so happy and proud to share. Are you people, can you listen to me? Is it going?
Yes.
Yeah. Okay. More than that, I'm so happy and proud to say that my daughter is a lawyer. She's an attorney. She passed out last year, and today she is just in a year and a half's time. She is an associate partner with a firm, and she's been always intrigued by the criminal law. And there is, anything said about Councillor Nikam sir is probably less. I myself, I'm so intrigued and follow his cases. It's been fantastic. Thank you very much for inviting me, and I wish you success, Councillor Aniket and Councillor Chadha. Thank you so much.
Thank you very much.
Thank you.
Thank you very much.
Thank you so much, sir, for this enlightening session. I must say it was really great as a law student to listen regarding these rules that you told us about regarding the cross-examination. It was really great. Thank you.
Thank you. Thank you.
Thank you, Manish.
so
Thank
much.
you very much, Aniket ji, once
Thank you.
again.
Thank you,
So
Chadha.
grateful to you for taking out time and being part of this wonderful session, I must say.
Thank you.
Thanks once again.
Thank you.
Thanks once again, and convey our best regards to sir.
Yes, sir. I will.
So
Thank you.
grateful to you.
Thank you.
So grateful.
Absolute
To you. Thank you
pleasure,
very much.
sir. Absolute pleasure to hear you today. Thank you so much.
Thank you.